Judgment has been reserved in the High Court in Johannesburg on the MK Party's challenge to former Judge John Hlophe's exclusion from Judicial Service Commission interviews next week. Our reporter Ziyanda Ngcobo is live there for us now to give us the latest on what to expect with this judgment. Ziyanda, good afternoon and thank you for joining us. What's the mood there as far as what the two parties have gleaned from Judge Wilson when it comes to that reserved judgment expected tomorrow?
Well, in essence, at least by tomorrow afternoon, judging from the conversation before adjourning courts, that by tomorrow afternoon, the judgment will have been handed down. The judge also emphasizing that, for a matter such as this one, he needs at least 24 hours to go over the arguments just before reserving his judgment. We heard from Advocate Hlophe rebutting some of the arguments that we've heard throughout the day. You'll recall that the DA, Freedom Under Law, and Corruption Watch were here today, although Corruption Watch didn't make representations in court here today. It was in the main the JSC, Freedom Under Law, and the DA. And in essence, there have been questions that have been posed towards the MK Party about, invoking of Section 18, which is basically looking at seeking to suspend, rather, operationalizing that order that was handed down by the Western Cape High Court. Lots of arguments about whether or not Part A that was handed down by the Western Cape High Court on the 27th of September is an interim order. Is there a difference between an interim and interlocutory application? And so there was lots of talk about that. The other aspect is why the MK Party didn't opt, for an example, to go straight to the National Assembly once that judgment was handed down to seek to replace Hlophe because of the order that was handed down by the Western Cape High Court, as opposed to seeking to postpone the entire sitting of the Judicial Services Commission. And lots of questions as well coming from Judge Stuart Wilson about what seems to be this intersectionality between the law and politics, and this him almost admitting that this is a political fight, but that has been brought before the courts, and whether or not the courts should be making comments on political decisions made by arms of the state such as the National Assembly. So this is also something that came under debate. So tomorrow then we'll get a better sense as to who won this case and what will happen on Monday. As we know, the MK Party has also promised to stage a protest if that sitting goes ahead without Dr. John Hlophe.
Ziyanda, it doesn't seem like the MK Party actually want to replace Judge John Hlophe, even if they had that opportunity, because Parliament went into recess, they had the opportunity, but it doesn't seem they want to replace him.
Yeah, and this is actually something that was also, spoken about during the court proceedings. We would have heard from the JSC and the DA arguing that it would seem that the interim relief that is being sought by the MK Party and Dr. Hlophe is quite bizarre. They would have thought, according to them, that the MK Party would have wanted, Dr. John Hlophe's presence to be pronounced upon by this court, as opposed to seeking relief of postponing the entire sitting. And so this is exactly the debate that was taking place. And the other layer that we heard from Ziyanda Ngcobo, who is representing Dr. John Hlophe, was that if you're going to ultimately make a decision that the decision to designate Dr. John Hlophe, the decision by the National Assembly, I should say, to designate Dr. John Hlophe to the JSC is irrational, then the same must apply for the other 5 designees to the JSC, because the decision was taken almost on a wholesome basis, en blanc, as they put it in the court papers, and and especially because they deviated from the normal parliamentary convention decision, which is to actually ordinarily allow political parties to nominate who they want to the JSC, and then it's almost rubber stamped by the National Assembly. But for the first time this year, 30 years into our democracy, those who were going to be designated to the JSC, it was a subject of debate. So that is the argument that was made by Ngalwana, to say that this decision was made in a wholesome kind of way, so therefore everybody should actually also be then barred from the sittings. But the rebuttal then from the DA was to say, well, it wasn't the other 5 designees weren't party to the Western Cape High Court a litigation which had Part A be handed down. It was only Dr. John Hlophe. It was only Dr. John Hlophe whose circumstances say that he is an impeached judge. And so this is the basis upon which the DA is making its core argument. As for the Judicial Services Commission, their argument was very simple today. Basically, they're saying there's a court order. Yes, it's an interim court order. And even if, according to Section 18(2) of the Superior Courts Act, you cannot appeal an interim order, and the order in itself also gives guidance on the consequences of John Hlophe's absence, looking at issues such as the balance of convenience and weighing up the cost. Is it better to just postpone, the sittings until the outcome of the full judgment of Hlophe's designation is dealt with, or do you continue with the JSC sittings without Hlophe, and what are the constitutional implications? This is something that the Western Cape High Court has already considered. Xolani.